The question, what is land, is a bit of a stupid question, right? Because at the end of the day, land is land. But in a legal context, we have to think a little bit more carefully about it, and we do so by considering dimensions. So if you imagine a piece of land on a map, that's obviously two dimensions, but we also have to think about the third dimension. So how far up to the sky does a piece of land extend? How far below the earth does a piece of land extend? Also, within the unusual context of English land law, we have a fourth dimension of time, which we'll cover in this lecture and hopefully not go down too much of a Doctor Who route, and also a fifth dimension of equity, which we'll discuss in much further detail. So let's get started. Let's begin by having a look at the best legal definition of land, and that comes from section 205, subsection 1, paragraph 9 of the famous Law of Property Act 1925. And even though this is a really old Act of Parliament, it's still really relevant for a lot of property law that we have today in England and Wales. However, in terms of this actual definition, despite it being the best one that they can come up with, it doesn't really go much further than me saying at the start that land is land. You'll notice that they do talk about things such as corporeal hereditaments and incorporeal hereditaments, but corporeal hereditaments just means things which are there. And incorporeal hereditaments is basically saying rights that a person has over land, such as rent charges or profits that are accrued from the land itself. So while it does go a little bit further, it doesn't really give us enough of a definition. And so we have to go back to these 5 dimensions of land that I talked about right at the start. The first X and Y axis I've already talked about in the introduction, and it's like looking at a map. However, one of the problems that occurs in English land law is that we have imprecise boundaries, and sometimes this can be a good thing because it allows for a degree of flexibility in terms of how the law is applied, and it doesn't hold the courts to a strict and fast rule. However, this obviously does create problems as well. So in the case of Rimmer and Pearson from 2000, there was a 22-day case that went through the county court over a 3-inch boundary dispute, and obviously this can waste a lot of the court's time and can also cost parties a lot of money. There was a dispute as well about a wall which had flower pots on it, and that ended up costing the parties £250,000 through legal expenses and things like that as it worked its way up to the Court of Appeal. And so what we have is that no map is really definitive in terms of how it defines land and the boundaries therein. So an ordnance survey map, or even the map contained within the deed to property, is not definitive. There are a number of common law ways of resolving boundary disputes, and I've put an example there of ad medium filium. You don't really need to know about these in too much detail unless you are writing an essay on it, but there are rules in place that basically try and act in a fair way when resolving these boundary disputes and seek to solve it in as simple a way as possible. There's also the concept of alluvion and diluvion, and this is again a very complicated word for something that is quite simple. This is just a person accruing land or land being taken away from them, normally through natural processes. So you can imagine if you lived on a cliff edge and due to coastal erosion, part of your land got swept away, then obviously that would be a case of diluvion, which is where your natural area of land is being decreased over time. We also have to consider the z-axis as well, and how far up does a piece of land go and how far below the earth does it go. And the traditional phrase from medieval land law is that your piece of land extends all of the way up to heaven and all of the way down to hell. Obviously, we need to be a little bit more precise in terms of the modern way that we define the z-axis, and so we can have a look at the different aspects of this. So beginning underground, a person has access to minerals and they have a right to the minerals that are underneath their property, but they don't have the right to oil or gas or gold or silver that occurs underneath their property. These still technically belong to the relevant authorities of the government, and so that's a bit contentious. There are other rules that come into play there, such as a license to mine for different things like oil and gas, and obviously that's something that you can look into further. There's also the idea of subterranean trespass. And if you want to find out more about that, then I highly recommend that you just put into YouTube, "I drink your milkshake," because the famous scene from There Will Be Blood explains it a hell of a lot better than I ever could. What about overground then? Well, since the sort of 1990s and before that, we've obviously got the idea that aircraft and regulating where aircraft actually fly. And so a number of statutory instruments at that time sort of declared that they shouldn't fly within 500 feet of buildings. And so that's a pretty hard and fast rule. What about the right to sunlight? Well, generally there is no right to have access to sunlight from your property. Although more recently, especially since 2003, there are rules that come up in relation to particular plants and trees that block a person's sunlight, in particular thinking of leylandii, which is a particular type of plant that grows really quickly. And a lot of boundary disputes and disputes between neighbours occur because of this particular plant. So there is arguably something of a right to access to sunlight because of these rules relating to the shadows cast by trees, etc. But generally there's no such right. We also have to take a common sense approach. So if you can imagine that you live in a 15-story flat and you live on the 7th floor, you obviously don't have access or the right to own all of the flats that lie directly beneath yours, or all of the flats that are directly above yours. And so that idea of from heaven to hell has really been reduced in recent times based on the nature of property in the 21st century. A few other things to consider is fixtures. That Latin phrase there that I'm not even going to try and pronounce basically defines fixtures as things which are attached to the property or form a permanent part of the property. And these are contrasted with chattels, which is basically just things which are there on the property but are not necessarily permanent. So you can imagine a contrast between something like an outhouse, which is obviously has foundations normally and is actually attached to the property. And so that is a fixture or a fixed part of the property itself. Whereas something that you might have in your house, such as a table lamp, for example, would just be a chattel. It's not attached to the property in any way. It's just plugged in at the wall and could easily be removed at any time. Now, that's a relatively obvious example, but oftentimes it's not as easy to decide what is a fixture of the property and what is a chattel. And so in 1872, we have Justice Blackburn in Holland and Hodgson, who came up with a two-part test to decide what is a chattel and what is a fixture. So what is the degree or the mode of annexation to the land? And also what is the purpose of the annexation itself? So this takes us a little bit further in thinking how we can define a fixture and a chattel. There's no real good rule on it though. A lot of people think of it in terms of the permanence of it, as I said at the start. Sometimes the way that I tend to think about it is, if you are moving house, is it something that you would take with you? So for example, you would take a table lamp or something like that with you if you were moving house, but you wouldn't take something that's fundamentally there, such as the boiler, because it's a fixture of the property itself. Other things occur in the Z-axis that might be sort of quite fun to consider. Treasure is always a fun one, and that comes under the Treasure Act 1996. If you do get a free choice on how you do your land law coursework, then treasure is always a fun one. Trees, plants and flowers that are on the property you do own. However, wild animals and birds that fly on or crawl onto your property you don't own, and there's various pieces of wildlife regulation that say, well, if the animal dies, then technically it's not alive anymore, so you would own it at that point, but there's different rules relating to that. Also, water, you don't necessarily have a right to water, but you could have it as a natural right to sort of draw from a well or from a river. And there's, again, different licensing that occurs in relation to that. So it's something that you could get more involved in if you wanted to research the law on it, but we're not going to bother with it here. So those are the three dimensions of land. The fourth dimension takes us into time. And this occurred because originally all of the land in England and Wales was owned by the Crown, technically. And so you wouldn't really own the land as such. Instead, you would own an estate in land. And so the idea of estates means that you can only own the property because the Crown allows you to. And so this principle or this conceptual element of land law in the UK introduces the fourth dimension of time and estates of land. And so the most common type of estate of land is the fee simple absolute. And if anyone ever says that to you, then I've put an English translation down the side, but it basically means that you own the property. Now, obviously, the Queen isn't going to come round if you buy a house and take it off you, because that's just not the way that anything works nowadays. But the idea of owning the fee simple absolute of land is basically another way of saying that you own the property for all time or indefinitely. And so that's where the time element comes into play. And so we can contrast this with the leasehold estate. And because we're saying lease here, don't think that this is kind of renting the property as such. And this is quite different. You still have ownership rights over the property. The only difference is that it's for a set period of time. But even with a leasehold estate, it will still often be for a very long time. So it might be 100 years, or it might even be like 1,000 years. But the point is that because there is a fixed limit of time, this is a leasehold estate rather than a fee simple absolute estate. Now, the fifth dimension is equity, and I have already talked about the principles of equity and the way that trusts operate in previous lectures. And so I recommend that you take the time now to maybe go and look over those if you want to see how this fifth dimension works properly. To give you a very brief summary, in terms of the principles of equity, the important thing to note is that when we're dealing with land law, we have to be dealing with it in a fair and conscionable way. And that's the principles of equity that I've spoken about previously. In terms of what you should take from the other lecture, in terms of how trusts work, the important thing is to note that with a trust, a person can own, more than one person, sorry, can own rights in property at any given time. And so we see a split of ownership in land or property between the legal owner, who has the legal title, and the beneficiaries, who have an equitable title. And there we have the basic understanding of what land is within a legal context. Now, obviously, if you're studying land law, there's going to be a lot more that you'll need to learn throughout the year, such as registered land, unregistered land, and all those sorts of things. But as long as you take this basic concept of the 5 dimensions of land with you as you go along, then everything else should follow from this and hopefully start to make sense. If you do have any questions, then leave those in the comments box below and I'll make sure to get back to you. Also, if you enjoyed the video, then make sure to leave it a like and subscribe for more videos in the future on land law, equity, and other areas of law in general. Thanks very much for watching. Bye.